existence at the time of the creation, just ascertainable.
That's part of our position, yes, Your
Okay.
Honor. Because I think you're really dealing with sort of three questions. One is the time at which this is determined. Do you do it at the creation, or do you do it when the class closes? They're arguing at the creation of the trust. We're arguing you look at when the class closes. You're also looking at...
And that event has not taken place yet.
Correct. And I would say, I think it's inherent in their argument that they sort of acknowledge that when the class closes must matter. Otherwise, what's the point in going on about how they're not going to have any kids in the future?
Right.
Which I think we set forth why, under the law, that presumption, the presumption is that they still would be able to do that for many reasons and under many different authorities, which I can repeat, but I'm sure you read. And I think that if you look at the Levy case, there's actually language that supports this. Specifically at 103 moving into 104, it says that the problem in that case was there was a double uncertainty, uncertain which class of children will be beneficiaries, and even after you determine the class, it goes on to say that not only are they not named, nor can they be ascertained now or hereafter according to any rule of descent or succession. So this is the court in the Levy case making a distinction between what you had there, which was orphan children, not necessarily orphan, fatherless children of Navy wardens. That's one of the possible classes, along with children, Hebrew children, and a few other different possible, according to the words of the document
And
at that
those
time.
would never be ascertainable.
Correct, because not by any definite method, as opposed to any rule of descent or succession, which seems to be pretty clearly talking about the type of situation we have here, where you're talking about the issue, right?
Right.
And it's something very commonly used in trusts. So that definiteness, our argument is that when you have a rule of descent and succession, until that class closes, you don't know whether you have anybody in there, and you're not, at the very least, you're not going to make that determination about whether it fails until the class closes. It hasn't closed yet. In addition, the point about the Sears Foundation, I would like to draw the court's attention to some contrasting language. If you look in Article 2nd at R41, and there's some language there where it references with respect to any trust under this Article 2. That's what it says at R41, where it's talking about one particular situation. But at R44 to R45, which is where this provision comes in to make it available to the Sears Foundation, it says, if no other trust is then being held pursuant to this agreement. So you see within the document itself that there's a distinction between trusts held pursuant to Article 2, and then the Sears Family Foundation, the provision to give it there, is actually a reference to the entire agreement. And so this, I think, leads into our point, which is that there is a third level decision to be made here. If for some reason the trust fails, our position is there's still an open question as to what is the appropriate remedy. I think in the reply brief they said something to the effect of we hadn't asked for affirmative relief, and therefore that wasn't properly before the court. I would disagree and say that we're not asking for affirmative relief because we think the court should just affirm everything that was done below. But in the event that you decide that something needs to be overturned, the question is then, what's the remedy? And the three possibilities, as I see it, are the rescission of the entire thing and then just leave it outright with the grantors, who were the beneficiaries, or some of the beneficiaries under the original trusts. You could also say, well, then you have to unwind the entire two-step transaction because we're talking about equity, and equity says that which should be done will be considered to be done. And here, the history of this case is that these two steps, the distribution out of the original trusts to the grantors of the successor trusts, and then the immediate funding of the successor trusts as step 2, that was all part of an integrated transaction which was designed to balance somewhat competing interests in the original trusts. The desire for tax savings versus the desire to go on. Sure. So that's a second possible alternative. And then the third one, actually, which to be honest, was one that had just occurred to me as I was looking through this in preparation for this argument. One could make the argument on that provision at R44 to R45 that all of the money should immediately go to the Sears Foundation right now if it fails. Because if they're saying, well, there's no trust for the primary beneficiary, one could take the interpretation on R44 to R45 that because there's no trust then in existence under this agreement, it goes to the Sears Family Foundation.
Okay.
I would say that that is certainly not what the trustees had been envisioning as we go along this, but I do think that it is a possible interpretation of the document.
Thank you.